on this evening. Professor Landman, thank you so much for joining us. And we hope that this will be an informative and a healthy debate regarding what I think is a very important and has become an almost dormant topic in law. Thank you, Prof. Landman.
Thank you, Siska, for the invitation. I just want to make sure that you can all hear me. Is it okay? Thank you very much for the invitation, and a special thanks to all the professionals attending. I know your time is precious. You don't have an 8-to-5 job, so I know what it takes to take time off and listen to a fairly old gentleman.
Dressed in red. Prof. Landman, if you could possibly just take us a little bit through, the definitions relating to assisted dying. A lot is said about euthanasia, a lot is said about end-of-life choices, but I would imagine that there are a number of categories relating to end-of-life choices, and it doesn't really, or it's not only really limited to assisted dying. But perhaps there are a certain number of definitions that we just need to get under our belt to have a better understanding of the topic.
Yeah, I think before I quickly address or briefly address the definitions relating to assisted dying, I should add that, the way you put the question is interesting. There was a South African Law Commission, now it's the South African Law Reform Commission, report issued in 1998. It was a result of a living will society that approached President Mandela and said they want to have living wills and other advanced directives, such as a durable power of attorney for healthcare, attended to by by legislation. The brief of that committee was expanded to 4 areas of end-of-life decisions. It was, first of all, treatment of pain, management of pain and suffering. Secondly, withholding and withdrawal of life-sustaining treatment, sometimes referred to, I think, unfortunately, as passive euthanasia. Thirdly, advanced directives, the 2 forms of advanced directives, a durable power of attorney for healthcare and a living will. And fourth was what we're talking about tonight, assisted dying, where the final report in 1998 put forward 3 options for consideration by Parliament. That report covered the international scene and had draft legislation appended to it. It was never tabled in Parliament. It died a death 15 years ago in Parliament. So if you want me to continue quickly on the definitions relating to assisted dying, or do you want to take up any of these points that I've just mentioned?
Yes, I think, Prof, what I omitted to say to our audience, of course, is that you welcome interactive participation. Yeah. We don't want it to be a passive seminar where everybody's bored to death and drink more than they listen. So I think at the end of the day, you would welcome interaction from the virtual platform as well as the physical platform. So please feel free to interrupt us at any time. Yep. Anything that you can elucidate on, or which would open up a different avenue in our debate. But I think let's kick off with the definitions, Prof.
Yeah, I think it's very important that that I am interrupted, that it's more of a give and take rather than a monologue from my side. But briefly, the definitions, and I'll consult my notes, just for the sake of brevity. We talk about assisted dying. And by that we mean two forms of assisted dying: physician-assisted suicide and physician-administered euthanasia. So physician-assisted suicide means that somebody supplies the means for another person to commit suicide, and that person commits suicide using those means. Physician administered euthanasia is where the means and the administration the means are supplied, and the administration that leads to death of the means is by another person. So, as you can imagine, euthanasia is performed on A by B, and assisted suicide is when the person receives the means and then administered it himself or herself. So these two are, you know, an umbrella term for these two is assisted dying. I should just add that from the point of view of a patient, we talk about voluntary euthanasia, that the patient chooses euthanasia and as a course of action given circumstances such as terminal illness and suffering. So it's voluntary. That's very important. People often say that it's imposed on somebody, that you'll kill somebody. It is a sine qua non that it is voluntary, that it's a choice, and the choice is made by somebody who's competent and makes the choice freely without being put under duress, or it's not an encumbered decision. There's also non-voluntary euthanasia, which is perhaps not the topic for tonight, but say a newborn baby who is euthanized, who's not capable of expressing a wish and therefore can't express it. And then there's involuntary euthanasia. I think for medical ethics purposes we can ignore that, but the fanciful examples of somebody in a truck that's overturned and that has explosives. The truck is on fire, and you come across the driver who's pinned down, and he says, "Please rescue me," and you actually, against his will, take out your gun and shoot him. That's against his will, but for his own good. So it's still euthanasia. For you know that the person is going to die. It's inevitable, and you. But so involuntary euthanasia, in other words, from the point of view of the person who dies, it can be voluntary, non-voluntary, or involuntary. From the point of view of the physician, it can be, we talk about active and passive, although I think that's a highly problematic distinction. Active being that you inject or you supply the means, passive meaning that you simply withdraw medical care and let the patient die, which is standard practice in our hospitals. We deal with terminal patients, but that is also what I call an action. An action can be an act and an omission, and all the variables apply to both of these. You know, whether we're talking about deliberation, taking a decision, motive, intention, direct consequences, indirect consequences. So those are the definitions of assisted dying in its two forms, and then from a point of view of the physician and the point of view of the patient.
Right. So what is the current legal position as we sit here this evening relating to assisted dying in South Africa?
I think the best source for that, direct source for that, would be the Stratton-Ford Supreme Court of Appeal. What the Supreme Court of Appeal said in Stratton-Ford, and it was in December 2016, that is that mercy killing, what we now call physician-administered euthanasia, mercy killing, is in all circumstances murder. So our law does not make allowance for that. That's what our common law says. It's a little bit more complicated when it comes to physician-assisted suicide. If there is a causal connection that can be proved, that stands up to the requirements of one of the elements of a crime, then it is murder. Then it is a common law crime of murder. But the Supreme Court of Appeal made it quite clear, not all provisions of the means that would be used by a patient or a person to commit suicide would constitute a criminal act. In other words, that if I supply, let me use a very simple example, and that is a doctor prescribes medication on a monthly basis for 30 days at a time, cautioning the patient that if you take all these pills at once, you will die. But he prescribes that with a clear prescription and a clear explanation. If the patient then ingests all 30 tablets at once and dies, the doctor is not responsible, is not criminally liable. If I send by courier a lethal agent to somebody who wants to commit suicide. And that person, there are several steps that that person has to take. Go to the courier company, collect the parcel, prepare for ingesting it, opening the bottle, mixing it with fruit juice or whatever the case may be. There are several actions, acts that break the causal chain. In which case, the court said, on a case-by-case basis, we have to prove that the supply of the means that led to the eventual death by somebody, death by suicide, we have to establish that causal connection. So it's a little bit more nebulous when it comes to physician-assisted suicide as opposed to mercy killing or physician-assisted euthanasia.
So in Strantham Ford, Prof, what was? Can you just remind us what was the position there? And as I recall it, our colleague who had in fact who was the applicant in that matter, he was a former member of the Cape Bar, I believe.
Yes.
He had passed away before the SCA judgment was pronounced. So was the SCA judgment not really just a kick for touch? And did they really then deal with the issues in relation to what was raised? And having said that, was that just simply on an individual basis, or was that with the view of actually changing the law? How does that case assist us?
I happened to be in court both at the time that Judge Fabricius heard the urgent application on behalf of Strantham Ford, and then I went to Bloemfontein for the appeal, for the Supreme Court of Appeal, appeal by the ministers and the Health Professions Council, etc. What happened there was, it's very interesting. A full day was set aside for the urgent application. At the end towards the end of the day, Judge Fabricius was ready to pronounce on the case. The Minister of Health, the advocate for the Minister of Health, the counsel for the Minister of Health, asked for postponement till the next day, sometime in the afternoon, and Judge Fabricius said no, 10 o'clock the next morning. So he didn't really want to do that, but he wanted to be fair. And what happened at 8 o'clock the next morning, Strantham Ford died. But we didn't know about it at the time. So that became one of the reasons why the Supreme Court of Appeal simply dismissed or upheld the appeal. Strantham Ford was dead, and the whole issue became moot. But Fabricius still went and wrote 60 pages of his, what would you call it, if it's the written piece, what is it called in technical terms? He wrote a whole week. He spent a whole weekend and wrote his arguments down, right? And the Supreme Court of Appeal then said that, this was an urgent application. All the arguments were not on the table. An ideal case or a suitable case would mean that all the arguments for and against by counsel on both sides would have to be put on the table. If we're talking about constitutional amendment or development of the common law, whatever is at stake. So he said that this is not the appropriate case, but he still, the 5 judges, Judge Wallace was the scribe, still, wrote a lengthy piece. First of all, dismissing the appeal on 3 technicalities, including the one that Strantham Ford was dead, and then proceeded to and we may come to that later, to say that a proper case will have these features. He actually, although we lost on appeal, I've always thought that it's a wonderful judgment, in the sense that the court, our 5 appeal court judges, some who applied their minds more so than others.
As is always the case.
I won't go into detail. They basically said that the law will change if a proper case comes to the court. The law will change, and they actually showed that, indicated that we may take the Canadian route of Carter versus Canada. And they said that there's not only a tension between the common law and our constitutional rights, but that the prohibition of our common law of all forms of assistance with dying is overbroad, and it is an unnecessary limitation of our rights, and that there's a defect. This constitutes a defect that has to be remedied. So very strong language, which a new case should take up.
So, Prof, if I can ask you, did the court say anything about the criminal liability of medical practitioners when it comes to assisted dying?
No, not anything specific. It simply, I think, what the court said about anybody who assists, whether it's a family member or a friend or a medical practitioner, would be in the same boat in terms of our common law at the moment. It doesn't matter. But it's interesting, when the court speculated about how our law could be adjusted, it suggested that one of the possibilities that you might find in some jurisdictions, one of the possibilities, there's several possibilities that they mentioned, was that a special defense for medical practitioners might be the way that we go.
So if you could possibly, Prof, just take us through the cases that you're familiar with in relation to, well, more particularly South African cases, and then you mentioned the Carter case as a precedent also, or as foreign jurisprudence for guidance. If you could maybe just give us a synopsis of the authorities, and how far it actually goes back into our jurisprudence, where this issue of assisted dying came about, and how it actually progressed, if at all, as far as the liability and the court's approach is concerned about assisted dying and medical professionals assisting with that.
I've over the years, I've been involved in this for a long time, and what one notices, not only in South Africa, I think this is important background to assimilate, in that not only in South Africa but worldwide, there's been a shift in, I should say, a shift in discourses, the way we talk about not only a right to die, but rights in general and rights in a medical context. I mean, in South Africa, I think the BICO cases were very important in the sense that one of the issues that came out of the BICO case and the doctors involved, that doctors can do wrong. I mean, prior to that, doctors were on a pedestal. Medical practitioners, you never really argued with what a doctor prescribed or what a doctor's diagnosis was and prescription was, prognosis. Doctors were on a pedestal. And what happened, that was a political shift in South Africa, that doctors were ordinary human beings who could do wrong, could do bad things.
So just tell us a bit about the BICO cases, for those who don't know. If you refer to the BICO cases, what are you referring to?
BICO was Steve Biko, the Black Consciousness Movement. He was imprisoned in the Eastern Cape. I think it was in then Port Elizabeth. He was assaulted. He was visited by doctors in his cells, and they knew that he had been beaten up badly, but they didn't. Their medical duties or ethical duties as doctors were really trumped by their allegiance to the state, because they were state doctors, state doctors. Biko was taken in a police vehicle from Port Elizabeth to Pretoria, where he died of his injuries. He was really badly beaten up, but the medical profession, really were the handmaidens of the National Party and whatever they did. So that, I think, played quite a significant role in the way which we looked at doctors and whether doctors can also be evil in a sense. Another development that is a worldwide one, and that is the rights language, that people have rights which they can claim for their own good against all authorities, including the right to autonomy, to take charge of one's own life and to make one's own decisions about one's own life and one's body as one finds fit, provided one does not cause suffering and harm to other people. It's your life and you can do with it what you want. Obviously, there can be implications, the insurance company may not cover you if you smoke and you take drugs and so on and so forth, but you will then make those choices and suffer the consequences. So there was a recognition of rights discourse, patient autonomy rights, and then consonant with that, rights around life and death. Is there a right to die? And if we have a right to die, do we have the right to solicit the assistance of others to die? And then it's also reflected in the public discourse, in the public domain, in social media, mainstream media, social media, radio, television. You can see a radical upswing in engagement on public forums. So that's the background to, if we look at older cases and younger cases. You must tell me if I'm droning on a lot. I'm sure there may be questions before I go and look at cases in our law.
No, that's fantastic. We don't have any questions at this stage online. Ross, do we?
Ask online people to go to Q&A.
Yes, our online attendees, if you could just maybe in the Q&A pose your questions and then we can put it to Prof. There's one hand that has been raised in the audience.
I just wanted to know about convictions and sentencing disparities. If there's been a consistency in sentencing over the years, if that's been fairly consistent with the finding of guilty for murder in assisted suicides, or is there been a lot of wild inconsistencies in the sentencing provisions?
Okay, Prof, I don't know whether you've heard that.
No, you just have to summarize that for me. It was an echo chamber for me.
The question is whether you have observed any disparities in the convictions and sentencing throughout the years where assisted dying and people or medical practitioners who've assisted been sentenced.
Well,
have dealt with that?
Very interesting. If we look at pre-1996, pre the new constitution, the cases that came up there, I thought showed certain similar features, and that is that when it was compassionate killing of another person, mostly then with that person's assent or that person's request, in response to that person's request, the accused had to be found guilty of murder in terms of our common law. But the judges invariably addressed concerns relating to compassion and the whole situation of somebody suffering terminally and unbearably and intractably, pleading for others' help. The judges invariably sentenced the accused to supervision, certainly not imprisonment. I mean, if you take the earliest case that, I'm sure there are many others, but the best known is that of Dr. Hartman, Dr. Albie Hartman in Sirius. I don't know whether you want me to elaborate on that, but Dr. Hartman was a GP in Sirius, and his father in his late 80s was dying of cancer. And he was stepping up the, I can't remember whether it was morphine, and then he instructed a nurse to, if my father complains about further pain, to step up the dosage. And as a result, the father died, and he was reported by this particular nurse or sister, I can't remember. And he ended up in Cape Town, in the Supreme Court then in Cape Town, where he was found guilty of murder, but he was sentenced until the rising of the court. So practically speaking, he was imprisoned until Judge Louis van Vincent had stood up and left the courtroom. He was set free. Obviously, it was a suspended sentence. The medical board obviously acted against him. There was Professor Snyman, who really was a difficult character. He made sure that Hartmann lost his license to practice as a doctor, although his patients, he moved from Ceres to Montague, and his patients of all racial groups drew up a petition to please keep him as their family doctor. They want him there, but he was suspended and he eventually disappeared. Some of his family ended up in New Zealand and so on. But the point was that he was sentenced till the rising of the court. Then there were two cases in the early 90s. The one is State versus Marengo, 1991, at Witwatersrand Division, then, where a woman shot her father out of for compassionate reasons. There were complications. She had mental issues also, and the way in which she was raised, and a very lonely figure. The father didn't want to be looked after by anybody else. He didn't want to go anywhere, and he was sort of thrust upon her. But he was also suffering of cancer, and she shot him. And she also didn't have a prison sentence. Then there was a case of Smorenberg, 1992, in the Cape Division, where a nurse killed 2 patients for compassionate reasons. She also didn't end up in jail. So you can see there's a pattern that, you know, if I can put it this way, that the judges feel that there's a kind of killing that is not, that is for the good of the one who is killed. And it's not like a standard murder case where you have evil intent and you actually want for bad reasons, if I can put it that way, somebody to die. And these are good reasons, in the sense that the one who dies wants to die, is at the end of life, and doesn't want to extend suffering. So that is, I think there's a pattern there before 1996.
But I think also the pattern continued, if I'm not mistaken, in 2019 with the Davison matter.
Yes, I think that's right. I think that's the only case that I can think of after 1996, the Davison case, where there was a plea bargain and he ended up doing community service for 3 years. He's a PhD who could have helped children with mathematics in the townships, but he was cleaning toilets in public buildings for 3 years. So, you know,
and he was also house arrest, I believe. There was a house arrest sentence, I believe, also.
It was a house arrest sentence, and he had to perform, you know, certain duties, community service. That is it, cleaning toilets.
Yes, Prof Landman, the Walter and Haag actions, those were in 2017 and 2022. Tell us a little bit more about that litigation, because I'm not sure whether all of that, in fact, litigated to completion, and what the current position is there, as far as you know.
Now, after the Strantham Ford appeal that was upheld, some of the advocates felt that they need to take another stab at it, and they found Dr. Sue Walter was actually attending physician of Dieter Haag, who was dying of motor neuron disease, and they lodged an application on behalf of these 2, call them patients, applicants, and there were several problems with that. As with Strantham Ford, it was an application on behalf of specific individuals. The argument was that it's not an application that would have validity only for those individuals, that it should be generalized from there for all individuals in similar circumstances. But it was an application on behalf of those 2 individuals. There was, you know, evidence was heard via one of these forums, one like the one we are on now. I think a Zoom, evidence was heard on Zoom.
That was during COVID, wasn't it? That when everything was virtually, the courts were virtual during COVID period.
Yes.
The pandemic.
Yes, but it was only to hear evidence. The arguments, were supposed to be led after that. It was during the time of COVID, and they completed that process, but soon after that, the judge died. They transcribed all the evidence, and the actual court case where arguments could be put forward on the basis of the evidence never took place. They were continual postponements. I then sort of played a role in contacting Dieter Haak and said, this seems like a dead end. We're not getting anywhere, and let's just terminate it and see what else we can do. What we can try a new avenue.
Okay, so that never came to fruition. In other words, that litigation.
No, it was withdrawn. No, although a substantial body of evidence was built up, which I then, we may get to that, I got involved in a new case, talking to new counsel, and they perused all of that evidence, but felt that the grounds for approaching a court should be quite different from what was the case in the Walter Haak case. So,
Prof, are you in a position to divulge whether or not
certainly what I did was to, when Dieter Haak had spent 5 years, and he has a motor neuron disease that progresses very slowly, which is fortunate, because the problem with any case like this, where there's an application or an action on behalf of an individual, that individual can die, and we have to go through 3 courts, the Court of First Instance and Bloemfontein, and then the Constitutional Court. And the chances that, that somebody who's terminally ill will survive these court processes are slim. So I contacted an old university friend of mine who is now a retired Constitutional Court judge, and we discussed tactics. And he gave me very valuable advice and suggested that I approach certain counsel, which I did. We have a team of 4 counsel, all in Johannesburg, so you would know all of them, whom I briefed. Dignity SA is the applicant. Significant is that they said that we should come with an ex parte application. Well, I'm meeting with them next Thursday to explain to them exactly what that means. I have a rudimentary understanding what that means, but at least it means we're not making an application on behalf of an individual or identifiable individuals. We're making an application on the basis of a problem with our constitutional rights, that a problem in our law, and to remedy a situation in our law. And as I understand it, this will be on the documents which we are preparing. I mean, I then briefed them in a written piece. They responded by setting out what they think should be the strategy. Amongst others, they said that they would then therefore need evidence of a particular kind, a whole list of kinds of evidence, clusters of evidence. And I responded by saying that I can appeal to this person in Canada and talk about the position in Canada, for example, about stories or about abuses in the Canadian jurisdiction or in Oregon. They need evidence on, the demand for it in South Africa, the views of physicians, the effectiveness of palliative care. Doesn't palliative care, that's proper palliative care, make the need for assisted dying redundant? So there are whole clusters of evidence. The essence of the ex parte application would be to follow what was suggested by the Supreme Court of Appeal in Stanton Ford, and it says, following Carter, as suggested by the Supreme Court of Appeal, or seen as a possibility by the Supreme Court of Appeal, is that we declare the existing prohibition of physician-assisted suicide for physician-administered euthanasia unconstitutional and invalid, that the court then suspends that declaration of invalidity for 24 months, allowing Parliament to correct that defect, and the court then directs Parliament to pass legislation to correct the defect within 24 months. I think in Canada it's 12 months. I speak under correction. So the court made it quite clear that the court cannot write laws. The court cannot legislate. But the court can point out to Parliament that there's a constitutional problem and that Parliament should rectify it. Therefore, Parliament should write the law, as it did with the termination of pregnancy, for that matter. So, in other words, that the prohibition on assisted dying, as it is currently in our common law, is overbroad, and it unfairly limits our rights. It captures people who should not be caught in this net. That we need to remedy the defect, and that is by passing the buck to Parliament. Which is another issue. I mean, whether they'd be able to do it is another issue.
24 months might not be 24 months after all, as we've now witnessed with legislation like Muslim marriages and the like. I think we've been waiting for legislation to be tabled since I started practicing at the bar 21 years ago. So I hope that you're building in some preventative or at least interim measure in the relief that you're seeking, because 24 months after all becomes a number of years. What I wanted to ask you, Prof Landman, is can you tell us on what grounds Dignity SA contends that the current position is inconsistent with the Constitution?
Well, in the Hague case, the operative or the main ground for application was that of dignity, that the prohibition of assisted dying does not give recognition to the constitutional right of dignity. Now, we believe that several rights are relevant to our application, but that rather than dignity, that of what I could call bodily autonomy, and I can read the right as it stands in the Constitution, said the right to bodily and psychological integrity, including the right to control over one's own body. In other words, to the right to make decisions about one's, your own life and body. We believe it's a I don't know what to say. It's perhaps a simpler case to make than the right to dignity, which in a sense is nebulous. There's a subjectivity about dignity in different communities. Some people can say something is an affront to my dignity, where the other cultures, you say, well, I don't mind. But when it comes to control over your body, I think it seems to be easier to prove. But it still means that there are other rights we believe that point in the same direction that could be the grounds for the application: a right to security of the person, including the right not to be treated in a cruel, inhuman, and degrading way. Now, you can argue that if I lie on my deathbed and the physicians and others want to extract the last few days out of my life, which to me is hell, I'm being subjected to cruel punishment if I cannot help myself and others who are in a position to help me do not help me. So that would be a second ground, and then dignity would also figure. And then I would say, to a certain extent, the right to life. And if we look at what Judge Cato Reagan said in the Constitutional Court, that the right to life is not simply a right to physical life, to biological life, but life, if I can summarize it in the way, life coming up to a certain standard, that is typically human life. That is the life that is at issue, so that if you, it is not an absolute right. No right is absolute, including the right to life. And that the life that is protected by the Constitution is a life coming up to having a certain standard. So in a sense, one can appeal, paradoxically, people would say that if one defends the right to die in terms of bodily autonomy and dignity, etc., that the counter argument to that would be a right to life. I would say no. It depends how it's interpreted. So to answer your question, all these rights, we believe, point towards tension, untenable tension with the common law. And I may add that we are going through a whole process since 1996 where rights are claimed that weren't recognized before. We did have certain very minimalistic abortion rights, but after 96 we have the most progressive and liberal abortion rights in the world, where a 12-year-old woman can decide about the continued life of the fetus she's carrying. We have same-sex unions. We have the abolition of capital punishment. We have labor rights that are being recognized. So we have reviewed the legal scene in terms of our constitutional rights. And in a sense, there are other rights too. I realize, in terms of, relating to drugs and to prostitution and so on. But this is in a sense the last right. R-I-G-H-T and R-I-T-E.
Absolutely. But let's talk about perhaps a little bit more. Let's talk a little bit more controversially. And I would like you to discuss with us the arguments that are against the legislation and legitimization of assisted dying. I mean, what immediately comes to mind is, of course, the diversity in South Africa and the different cultures and religions and their opinions about assisted dying. If you could perhaps talk a little bit about that, Prof, and of course, the morality behind assisted dying. What part is that to play in this whole process?
I think there's an ethical debate which has been going on for millennia, I guess, ever since Hippocrates, had an injunction against in the Hippocratic Oath against taking the life of a patient. Although that stands open to interpretation in the context of 2,500 years ago. But there's an ethical debate where people feel very strongly on both sides that it's either ethical, it's morally acceptable, or it's unethical. It's morally it's unethical, morally unacceptable. And there are very strong arguments, pivotal arguments on both sides. And I think there are three main arguments on both sides, and we can look at them. But I think the outcome of that will be that it will be a perennial debate. Debate will never end. We will never come to an agreement. At this point, I can look at some of those arguments, but I think the move that why we try to change the law in South Africa is that we shift from the ethics of assisted dying to the ethics of decriminalizing assisted dying, the ethical imperative to actually act according to our Constitution's Bill of Rights. Now, the Bill of Rights I consider to be an ethical document in the first place. It sets out rights that are grounded in certain values and norms. And from those rights spring certain principles of conduct. So I think the Bill of Rights is an ethical document that sets the parameters or the foundation, as it were, for us to build a just and fair society. And the Constitution is the outcome of an agreement that was reached on the foundation for building a good and fair society. So the ethical debate has shifted from ethics in general, arguments about culture and religion and suffering and autonomy, to ethics in the context of the Constitution. And all these rights are grounded in ethics. I mean, there's this famous, wonderful quote by Earl Warren, a former Chief Justice of the United States, who says, he said that in civilized society, law floats in a sea of ethics. In other words, all the legal injunctions and rules we have are there and recognized by us, because underlying them is a sense of justice, in a sense of ethics. And we certain rules that we have, certain ways of doing things, we couch into law because they are so important to us. They reflect what is underlying them. And I would argue even the most arcane rules of accountancy can ultimately be reduced to issues of fairness and whatever the case may be. So the debate has shifted to the law, but it's fundamentally an ethical debate about what our Constitution allows.
Yes, because I mean, if we think about it, then it might not be religiously acceptable to be for same-sex people to be married. I might not be in favor of abortion. But as you've indicated, Prof, I mean, the Constitution in South Africa has made it possible that these things become legislated and that they become legitimate, of course. So, I mean, certainly then isn't that the end of the cultural and the religious debate then, as far as assisted dying is concerned, or am I simplifying it more?
No, I think you're exactly right. No, we have a constitutional democracy. In that democracy, particularly in South Africa, more so than in some other communities, say like the Scandinavian communities, we have a diversity of cultures and religions, a diversity of personal persuasions. Now, how do we accommodate them all? We accommodate them all by saying, these are the ground rules. These are the ground rules in the sense of rights in the Constitution. If we play by those ground rules, we may live in a society, we'll have arrangements in that society where certain ways of doing things, we disagree with, and you've mentioned them. It may be same-sex unions, it may be termination of pregnancy, but we have to accept them because the Constitution says that the only way we can accommodate all these different views is by playing by the Constitution. But please note that all those recognition of all those rights, I don't harm anybody. A woman who has an abortion or termination of pregnancy doesn't harm anybody else. I mean, and that other person who has an objection to that doesn't have to choose it for herself, or the husband doesn't have to prescribe to his wife what to do. So we need to accommodate various persuasions. You can equally say, as you can say that in some cultures are resistant to assisted dying, but you always get exceptions. Some people argue that in the Christian religion, it's against assisted dying. I do not see that. I do not see it at all. I think it's a particular interpretation of the Christian religion, and you can call upon a former Archbishop of Canterbury or to Archbishop Desmond Tutu, who are Christians. Many Christian theologians who would argue that assisted dying is completely consistent with Christian precepts. Now, you can have the cultural argument. You say it's against my culture, my call it whatever, X culture. And then another culture can say, but, well, it's completely consistent with my culture. My culture doesn't object to it. Now, what does one do? Do you fight about it? No. The Constitution will arbitrate. The Constitution will say that, what is, in terms of constitutional rights, is acceptable. And others who disagree will have to accept it. Because If I choose to die 2 weeks earlier because of the suffering being unbearable and intractable, nothing can be done about it unless you put me in a permanent coma. And I don't want to live, I don't want to think of myself in a coma for two weeks while, Discovery gets more money and it's my family are deprived. I don't want that knowledge that I'll be, a ventilating corpse for 2 weeks. Why can't I'm not harming anybody else. I'm in the privacy of an ICU, for example. I'm not harming anybody. So the issue about the recognition of these rights is that you have to tolerate what others that others disagree, and you're not harming anybody.
Prof, now I wanted to ask you, we went through a whole rigmarole at one stage when same-sex marriages were legitimized, where marriage officers had the difficulty or the moral dilemma, for the want of a better description, where they said the legislation, in fact, at some stage, it was interpreted that they had no choice but to perform these solemnizations of these marriages.
Yeah.
Now, within a medical practitioner context, of course, is this something that the medical practitioners who really are not in favor of assisted dying would also be in a position where they might be forced to do the same? And are we going to have the same debate akin to the marriage officer debate?
I think in all jurisdictions that I know of where assisted dying in one form or another has been legalized or decriminalized, there is an escape clause for medical practitioners who find it profoundly, unethical in terms of their professional values, that they can opt out. But the proviso is usually that they will find a substitute who would help, that you don't just send a patient away, destitute in a sense, at wit's end about finding somebody who would help, especially now if it's legal. I mean, you have a legal right and you can't exercise it because there are people in the medical profession who have conscientious objections. Yes, but then find somebody else. And that is what is happening also with termination of pregnancy. But I should add, that we have organizations like Doctors for Life who are almost violently opposed to legalizing or decriminalizing assisted dying. The argument is often that doctors, the professional duty of doctors is to heal and to save life. Fair enough. We will all die. It used to, the Bible used to say 70 years plus 10. 70 years plus, what is it? 70 years plus 10, which is 70. Well, then I should have been dead for 4.5 years already. But I think that I've lost my train of thought here. I think that the problem is that doctors should accept dying, the process of dying, and the end result, death, as part of life. We will all die. So it's no use saying, I'm going to fight to heal and to extend life and to save life if you reach a point where it's impossible. So I think doctors should take that on board, and they have not done so. Many have not done so adequately. And, it's very interesting to note that most of the calls I get are, letters and calls. How can, I want to depart. Can you give me something that I can take? The most calls I get are from people in I won't mention the hospitals. There are some that are more prominent than others. They're close to you, where patients are kept alive against the will of the patients. If the patients are not able to express their wishes, they're kept alive against the will of the surrogate decision makers, namely the family of the patients. They get visited every morning by 3 specialists who invoice Discovery, for daily visits. It's extended for weeks. And if they, ask me for advice, I say you have a legal right. That stands before the SCA full bench of the Supreme Court of Appeal said, any treatment, any medical treatment must be with informed consent. Any treatment against the will of the patient, and by implication against, if the patient cannot express his or her will, by the surrogate decision maker, the proxy decision maker, against the will of the decision maker, is assault. Then I tell them, you tell the doctors that. And then they throw up their hands and they run out when they know that they've reached the end of the road. So I'm wondering, why did they follow that avenue? So there's a sense in which some doctors, I'm not accusing the whole profession, actually lean on this whole professional dedication to saving life, even in even in inappropriate circumstances.
Unsavable circumstance. Prof, before we ask for further questions from our audience, I wanted to ask you something on a practical level that I grapple with. Seeing that I have an 86-year-old mother, I don't know how long ago then in terms of the Bible she was in fact supposed to, but anyway, I'm grateful every day we have to spend with her. But on an annual basis, we renew her living will, because we're told that is what we should do. But what is the effect of a living will ultimately, especially now that you've described what happens in some hospitals? And for those who stay behind, who see the loved one going through that agony, and you have this document in your hand, I mean, ultimately, is it worth the paper it's written on?
It's a very difficult question to answer. I would say that if the patient is unable to express a wish, then in terms of the National Health Act of 2003, a substitute decision maker is appointed. There's a whole sequence of which family members and what sequence they become surrogate or proxy decision makers. What they want, what they express to be as a preference, should be heeded, as I've just said. The living will, I think, if it can corroborate that decision, can support that decision. And so I think a doctor who denies that a living will has any evidentiary value is on shaky ground. Now, if you look at I personally think that the living will is in a sense embedded in the National Health Act of 2003, in the sense that the premium it puts on, the emphasis it puts on informed consent. And if you read it in context there, you can say, well, I can argue that there's an embedded living will there, that I give my consent for X, Y, and Z for a future state where I'm time where I'm not in a state to express my wishes. So, but the problem is it is not explicit, which is unfortunate. The South African Law Commission had a whole section on that and said it should be legislated. We, as Dignity SA, worked with parliamentary law writers and actually had an amendment, everything ready for an amendment to the National Health Act of 2003, explicitly legalizing a durable power of healthcare for durable power of attorney for healthcare and a living will. But there was an election, new parliamentarians, a new parliament, so the whole thing fell flat. But it's there, it's been written, but again, nobody's taken it up. There's no political will. So I echo in a sense what you're saying about giving Parliament 24 hours. I mean, that dysfunctional body, whether it will be able to write a law in 24 months, I don't know, but they will have to get help. So the legal position of a living will is ambiguous to say the least. But I think a doctor who simply ignores it, if a family takes that doctor to court, the doctor will have a very hard case to prove.
Yes. All right, Prof, I don't know. Let's just check whether our audience wants to ask any questions. Yes, Nada.
In the cases that we've had already, how much involvement has the HPCSA had in voicing their view? Have they been acting as amici at any point? Have they been respondents? Apart from the fact that we know that they've had their side proceedings, disciplined doctors, but within the courts, have they been involved?
All right. Prof,
HCSA,
did you,
right?
Yes. Has the HPCSA taken an active role as amici in some of these matters is the question.
Very much so, opposing Dignity SA at every opportunity they get. In the Strantham Ford case of 2015 in North Gauteng and Pretoria, the HSPCA joined forces with the NPA, the Minister of Health and the Minister of Justice and Correctional Services to oppose the case put forward by Strantham Ford. They also joined the HPCSA, joined the ministers and the NPA in the Strantham Ford appeal. And we have good reason to believe that they were going to oppose, in fact, it might have been so, I'm speaking a correction now, the Haak Walter case too. So, I mean, that is the difficulty we have. It's simply a matter for constitutional interpretation. On the one hand, you have, the purse of the state, and in a Pavlovian way, they simply oppose. On the other hand, we have to raise funds, from people who feel strongly about this and get pro bono representation and top that up with other funds. So yes, the HPCSA simply opposed every effort that we've had.
But it certainly does not appear to be the view of all of their members. If one sees how doctors have been, some doctors have conducted themselves and in fact found themselves in trouble as a result. It's not necessarily the majority view. We can't accept it as a given.
Of doctors registered, you mean registered with the HPCSA? No, I mean, that's right, but the HPCSA is a thoroughly politicized body. So, but why they have to align with one, I'm not sure. I'm not sure what kind of political opinion that is, what that constitutes. The problem is one problem is that you could argue that there are far more serious issues at stake with termination of pregnancy, where you have a potential life being cut short, etc. But the fact is that women form more than 50% of the voters of this country. So it was politically expedient to have something in terms of women's rights. To have the termination of pregnancy legislation. The people who are dying are not a voting bloc that can really harm the ruling party.
Well, then I hope that you do have female counsel on your team, because it looks like women have the power.
The foundation of our team is a female counsel. And she's going to do the solid research, and we're finding funds beyond pro bono involvement for her. So she's the rock and foundation.
That's good to know. That soothes my feminist heart. Prof, we've got one comment in our box. It's from Sitole Maselaelo. He says, "I'm very happy about the progress that you are making in this regard. I've also researched on the topic focusing on dying in dignity after Strantham Ford when I was doing my master's at university." And he also says he had a special interest in the topic, and most especially after the death of his aunt, who suffered unbearable and constant pain as a result of cervical cancer. So it would appear that there is quite a bit of support.
I think that's very interesting. I find that people who are lukewarm, some of my friends can't understand my involvement in this. In retirement, it was before retirement, they can't understand why I'm doing it, because I'm doing it for nothing. I'm saying not for nothing, it's the real people who suffer. And I find that people who understand what I'm doing are invariably people who have found a family member dying under dire circumstances. The interesting thing is that it's only a minority of people who will die in those circumstances, who cannot, where medical science actually is not helping them, but making it worse. So it's a small minority, but if you encounter that, well, if you're in that position yourself, or if a family member goes through it, you make a switch, you focus on it. And I guess that's true of many things in life, that we only focus on it really if it touches us. Yeah.
Absolutely. Okay. I see that there's another. Yes, another.
Sorry,
No problem.
I find that Prof mentioned that we're moving more from the ethics of assisted dying to rather the ethics of decriminalization. Just for interest, I'd like to know if, in the course of interpreting these rights, like the right to life and the right to dignity, how much of the philosophical debates played in a role as well, in addition to the religious and moral issues. How much, like, this is an issue that's been written about since ancient Greece, you know. You had Aristotle talking about how the right to life isn't actually yours. It's given to you, whether by higher power, whatever, but you can't take it away. You've got Hippocrates also, who said, look, it's actually more of an affront to society than yourself, for you to take the matter into your own hands.
Yes.
So how much did those actually, like?
So how much weight has the philosophical, or how much has the philosophical debate featured in these issues, Prof?
It's going to be very interesting. You know, a meeting that I have with council next week will probably reveal how much they will lean on ethical issues. On philosophical underpinning of the legal debate. Now, if I could just use one example, in the Strantham Ford appeal case, SCA case, Judge Wallace and the others talked about, you know, we need arguments around assisted dying embedded in a rounded view of society. Now, I'm not exactly sure what they meant by that, but I think we have to interrogate that. In other words, that the outcome that the court reaches must somehow be harmonious with a view of society that's integrated. That in a kind of society we live, we grant people the right to same-sex unions, to termination of pregnancy, to assistance in dying, that there's some kind of philosophical argument about the underpinnings of our law in terms of a concept of the good in a just society. But I'm sure that the judges, and this is what I want to discuss with our council, amongst others, judges will ask questions about purely philosophical questions. For example, we talked about the question of culture. What do we make with people in our society? We feel really this is an affront to our culture. How are we going to handle that? The religious argument, whether it's Christian or Islam or Judaic religions. What are the philosophical arguments about physicians' duties? The one we talked about. How do those duties change at the end of life? And then there are more empirical arguments, but also philosophical ones, and that is that if we institute this and we do not safeguard the practice properly, it can lead to error and abuse. Now, I find the counter arguments are actually fascinating. You put the argument, you have counter arguments. Now, we do not ban a practice because of its errors, that it's possible errors and abuse. We do not ban cars from the road because some people drive drunk and they cause the death of other people. We try to control the practice better. And I think some analogy is necessary here. We're not suggesting that we'll have a practice of assisted dying that's legal. That'll be without error and abuse. Although if the safeguards are proper and that Parliament need to set down those safeguards, if we look at other jurisdictions, it's done very, very successfully. If you look at the 25 years of reports from Oregon, now the first report is out from New Zealand, and where it's tightly controlled. And remember, this is not something that happens out there where you it's not similar to street violence. It happens in the sanctity of ICU at a hospital bed. It's not out there. So that is where it needs to be controlled, with two physicians making giving approval, etc. Then there are the arguments for that we're in a society where we appreciate and we value self-determination or autonomy, where we choose certain things for ourselves. That some like rock face climbing and at the risk of falling off the rock face and dying. We allow people to do that, you know. Why that and not you know, other similar choices, and arguments about the suffering, the philosophical underpinnings of suffering. Some people say we have to suffer to become better people. Do I have to suffer in the last 3 days or 5 days, 7 days of my life to become a better person? I've lived for 3/4 of a century. I'm not going to get better in those last 3 days. I'm going to get worse. So there are philosophical arguments, and then just the last one, and that is, we allow withholding and withdrawal of life-sustaining treatment. We can let people die. We can withdraw life support. We can say that if somebody in this condition gets a lung infection, we're not going to give antibiotics. What's the difference between that and actually helping somebody to die by means of assisted suicide?
Yeah.
The variables of responsibility, both ethical and legal, for an action are there. You have deliberation, you have to make a decision, you have to execute it, you have to have motive, you have intention, you have to have direct consequences of dying, indirect consequences for the family. In both ways in which one can die, by withholding a withdrawal or by in a compassionate way helping at the end. All these variables are the same. It's not that all stack onto one side versus another. So why do we allow one and not the other? From a philosophical point of view.
So it sounds like it will weigh. It will take a bit of limelight in the argument, the philosophical argument of it all, because it's infused in many facets. And as you've said, the Bill of Rights is quite a philosophical document itself, isn't it?
Yes.
Prof, there's another interesting question by one of our audience members online. Yolanda Giudoci is asking, can Prof Landman describe what he envisages for the regulation and control of assisted death if it were to be decriminalized? Is the National Health Service meant to be involved?
Well, I can only, let me preface this by saying that this is for Parliament to decide what we as a society can tolerate. What do we, for example, some would say that before somebody's approved for assistance with dying, in whichever form, we have to have somebody certified, you know, qualifying in terms of the requirements by 2 independent medical, you know, practitioners. Some would say, now, in what do they have to be specialized? Do they have to be specialized specialties or specialize in a specific field of that what that patient is dying of? So others said, no, you know, you can have a general practitioner or a generalist physician simply making those pronouncements. But typically it would be that 2 doctors independently, 2 medical practitioners independently say that this person qualifies in terms of the standards. And it may be, now there's another big issue. Do you have to say somebody's terminally ill? And what do we mean by terminally ill? Is it somebody who's going to die within 6 months, which is the usual definition? Or what about suffering that's intractable and unbearable? That's mental suffering, but you're not terminally ill. We'll have to decide about that. Then somebody has to request it, and the request has to be repeated with, say, a time lapse in between of 7 days or whatever the case may be. Parliament has to decide about this. Does it? You have to be. It has to be made clear that you can retract your request. That you're not. You know, it's not inevitable that you carry through with your request. You have to be competent. You have to be. Your decision has to be unencumbered. It has to be a free choice. Somebody has to look at this. So these are the kinds of decisions that will have to be made about the safeguards that we would build into the system. There was another aspect to the question that slipped my mind now.
Is the National Health Service meant to be involved?
I have no idea what shape or form that will take. You know, I despair if I look at our public hospitals, where just this morning I wrote that over the past few years, 800 babies died in one of our hospitals. So I don't even want to think about how this is going to, but I can say to you that if we take life and death decisions already in terms of withholding withdrawal of care, then, you know, it's not a huge step to accommodate this, but I can foresee this only being accommodated in certain facilities, as we have ICUs in certain facilities and so on. I cannot see it happening in rural clinics and so on and so forth until the proper infrastructure is there. But you know, I'm in the region of speculation here. Mm-hmm. But I do believe that our medicine, our medical fraternity and sorority are of such a standard that we can do it. We can do. We always want to be the best at everything. We're a whole range of things that we're the best of that I'm not proud of. But there's no reason why our medical infrastructure cannot handle this.
Yes. Prof, there's another question by Alfred Wolper. He says, can you request the medical professional to withhold and or withdraw the medical treatment and insist or ask for pain medication? Not sure whether that question is clear to you. Otherwise, we can ask Alfred to
just answer and then say whether you think I've answered the question. Another thing that Strantham Ford, the 5 Appeal Court Justice, said, remember that we can apply pain medication. We can administer pain medication as much as needed by the patient to eradicate the pain, even if it hastens death. Made it quite clear that if the secondary effect, I mean, sometimes referred to as, and I think the Supreme Court of Appeal referred to the doctrine of double effect. If your primary intention is that of eliminating pain, and the secondary inevitable and foreseen consequence is that the patient's life will be shortened, that is legally acceptable. I'm not sure whether I've answered the question, Siska.
Yes, I'm sure Alfred will let us know if he needs to elaborate on, or he requires elaboration. Alfred, you're welcome also to unmute yourself if you need to ask the Prof. Yes, he says the answer is yes. No, that was from someone else.
That was Yolandi.
Yeah. Okay. Any other questions? Such a light topic for a Thursday evening.
Luckily it's Friday tomorrow. But maybe I should just raise one issue that hasn't come up, and that is if palliative care is optimal, is assisted dying redundant? Is this all a red herring? The tough question. I don't think so. If I choose not to, even if it alleviates my pain, but I suffer mentally, and I choose not to carry on with palliative care, I should have the right to make that choice. I want to preface this by saying palliative care is enormously important. It's not an either or between palliative care and assisted dying. I think they go hand in hand, and I don't think I'm talking out of I'm revealing state secrets here, but I've had a very uncomfortable relationship with the palliative care and hospice movement, with the previous CEO who also opposed everything we did. They have a new regime there, and they are reviewing their policies of hospice and palliative care in view of the public debate on assisted dying.
It looks like there's another seminar on coming in the pipeline, Professor Landman, especially after the ex parte application. We'd love to talk to you after that. But palliative care in itself, I suppose, and hospice in itself will create quite a bit of debate and discussion. But if there are no other questions, Prof Landman, I just want to say on behalf of myself, the Bridge Group of Advocates, and everybody present on the virtual platform. Oh, there's another question. Sorry. Hi, Prof.
You have to postpone your dinner at home.
I have to now postpone my Sauvignon Blanc. When the SCA
should be Cabernet.
He says, this Bukosi Mtukushe, he says, hi, Prof, when the SCA says as much analgesia may be lawfully administered by a practitioner to a point where it could cause death, wouldn't a medical practitioner who administered such doses find him or herself at odds with the HPCSA standards on drug administration, especially seeing that the HPCSA has opposed attempts for assisted deaths?
You know, to answer that question properly, I'll have to look at the HPCSA's policy on pain control and treating suffering of patients, but I am almost sure that they would not deny, in other words, they wouldn't support undertreatment of pain, that they would say that treating pain adequately, and that is insofar as the patient needs it and expresses that need, that would be in order, even if it hastens death. You know, in the end, it may hinge. I mean, you as lawyers would know better than I would. You know that it hinges on intention. I mean, if you administer X dosage of morphine, and you know you're doing it to alleviate that pain, but you know an inevitable consequence will be death at this level, what's the difference between that and simply injecting and saying, you know, I want to relieve you of your suffering by causing death and not by having death as a secondary consequence. It's a fine balance, but you know, I think that a doctor would always be called upon to justify that level of, and it varies. You know, the level of the morphine, for example, would vary in terms of the patient's exposure to morphine, tolerance to morphine, so that for what is a lethal dose for one person would be far from a lethal dose for another person. So if there's a query, it'll have to be interrogated. What was the appropriate level, and was it unduly stepped up? You know, stepped up too much. That kind of question would, I think, would arise. Yes,
becomes very grey, I think. All right, Prof Landman, thank you so much again on behalf of the Bridge Group of Advocates and all my colleagues present and everybody else online. We've sent out invitations as far as the Cape Bar. I see there's also colleagues of the Cape Bar that are also present. Alfred Wolpe, of course, is awesome, informative session. Thank you, Prof Francisca. I found this so valuable. Hope there are more of these and follow up. So, Prof, you're locked in now. Sorry. We're going to bug you again for future discussions like this. But thank you so much for your time and good luck with the foreshadowed litigation. We hope it goes well.
Thank you for the invitation and for all the time that you know, of all the attendees. For the first time in years, I've been persuaded to make use of this medium. I always said I would not do that. I would rather develop my wildlife photos than do this. But you've persuaded me, and I've enjoyed it. Thank you very much.
It's a great pleasure, Paul. Thank you so much. Okay, Willem, ek sal môre met jou gesels, hoor.
Okay, Siska.